Thank you for being with us today. Fairfax County in Virginia, the state where I'm from, has moved towards equitable grading. Could you talk briefly about that equitable grading and the harm that's being done from that?
I'm not familiar with the policy.
Okay, well, equitable grading is its stated goals to combat institutional bias and eliminate racial disparities in grade outcomes, and it removes grade penalties for late assignments. And so, but I see I'm out of time as well. I yield back, Mr. Chairman.
Thank you so much. Appreciate that. I'd like to now recognize Mr. Courtney.
Thank you, Mr. Chairman. Mr. Hinojosa, one of the traditional strengths of our system of laws, common law, as well as legislating, is the principle of legal certainty, which is that and it's been expressed, is that the law must be accessible and, so far as possible, intelligible, clear, and predictable. I mean, people rely in terms of just organizing their lives and their enterprises, in terms of just having clear signals from courts and legislative bodies, in terms of following what I think has really always been a really important and positive principle. Your testimony on page 5 notes that for those who think that the court made the admissions process completely race blind. In fact, as you point out, there is language in there that suggests that there still, is under the law the ability to, conduct admissions in terms of how race has affected an applicant's life, be it through discrimination, inspiration, or otherwise. So I was home in August and talking to some educators in higher education, as well as other secondary school institutions in Connecticut. And I have to tell you, the principle of legal certainty was completely trampled by this court. And again, setting aside all of the, political arguments that are here today, I mean, the fact of the matter is that if you're an admissions office right now trying to figure out, with this decision about how to make choices in terms of applications, I mean, it is really almost just chaos in terms of just trying to decipher this. I mean, they are talking about actually bringing on legal counsel, to really screen sort of what the court actually left them with in terms of this decision. So I was wondering, again, I know the DOE is talking about trying to get some guidance out there, but the fact of the matter is this court has really left a mess as a result of this decision, regardless of how people feel about the merits of affirmative action.
And that mess started with the court's own unjust, tortuous interpretation of the Equal Protection Clause, even suggesting that Brown v. Board somehow would support excluding black and brown students, highly qualified black and brown students, from our nation's most selective institutions. And that's sad. I carry a copy of the same pocket guide that I got from University of Texas School of Law when I went there back in the 1990s. And but what's most troubling about the more recent opinion is that you have Chief Justice Roberts almost trying to dictate educational policy. He's a Chief Justice. He should limit his opinion to the issues that are before him, but he didn't do that, and he started trying to write, policy, and which has thrown confusion. But it's been made even worse by organizations like Students for Fair Admission, suggesting that the whole process has to be race blind. That absolutely is not. If Chief Justice Roberts, just as an example, if Chief Justice Roberts says, yes, you can consider race as a notion of resilience and the like, right? And overcoming discrimination. So how can you talk about racial discrimination, overcoming racial discrimination, and somehow have to divorce race from overcoming race discrimination? It doesn't make sense. But when you talk to lawyers, they will tell you that's what the opinion means. And that's why we have, some chaos that's been created in many boardrooms at colleges and universities and in K-12.
Well, again, this seems to be a trademark of the Roberts Court. I mean, if you look at the Dobbs decision, I mean, it's the same situation that's happening in hospitals and clinics all across the country, where OBGYNs are feeling the need to have legal counsel to advise them about how to practice medicine. Because again, it's just, they've created all these cross currents of possible criminal liability, as well as professional liability, in terms of just stepping outside lines that are not clear in terms of just how they're supposed to practice medicine. Again, moving forward, though, I mean, it's clear that, in my opinion, Congress needs to act to set some clarity so that we can, again, allow our legal system to achieve a goal that has always been, recognized as essential.
Yeah. And we need to make sure that students understand that their full experiences should be represented, and that universities shouldn't shy away from that. In fact, they might be running afoul of students' First Amendment and 14th Amendment rights if they try to censor students' stories simply because they're related to race.
Thank you. I'd like to now recognize Mr. Moran.
Thank you, Mr. Chairman. Ms. Salmon, I want to come to you just for a little bit of response for Mr. Hinojosa's criticism of Chief Justice Roberts. When you look at his writings, and he said in particular in the most recent opinion we're focused on today, about the dissenting opinion, that he said, the dissenting opinion defends, quote, a judiciary that picks winners and losers based on the color of their skin. What would be the consequences if our judicial system applies different laws based on race?
I agree that that would be very concerning. Individuals should be treated as individuals when they come before the law, and a judiciary that doesn't do that I would be very concerned about it.
Last week, the Students for Fair Admissions filed another lawsuit against West Point Military Academy, U.S. Military Academy at West Point, and the Department of Defense, citing the military academy's use of race as a preference in admissions. In fact, West Point publishes racial composition goals for every class, and these goals are adjusted yearly to reflect the enlisted population. During the Students for Fair Admissions Harvard and UNC oral arguments, what was the discussion around the military academy's race preferences?
There was a discussion concerning whether this was the kind of compelling interest that would evade strict scrutiny that would allow the military academies to use race.
And given the Students for Fair Admissions decision, how might the courts rule in the West Point Military Academy lawsuit? Do you have an opinion about that?
The Students for Fair Admissions decision makes it clear that what's known as strict scrutiny applies to the use of race in admissions everywhere, including the military academies. Any use of race must serve a compelling interest and must be narrowly tailored to serve that compelling interest. That is, the institution can't use race any more than is necessary. In the military context, what that compelling interest might look a little different than the civilian context. Nonetheless, given the toughness of the standard enunciated in Students for Fair Admissions, I'm skeptical that the military academies will be able to meet that heavy burden.
Okay. Mr. Squires, I want to come to you now for a few questions, if you don't mind. In an article that you and your colleagues from Heritage wrote titled Created Equal, a Roadmap for an America Free of the Discrimination of Racial Preferences, it states, quote, ending racial preferences will provide opportunities for policymakers to focus on often neglected factors that contribute to student success. My question to you generally is, what are those neglected factors that you were referring to in your colleagues when you wrote that article?
So I believe what we were referring to in our special report that came out after the decision, particularly was around family and family structure. And as I said, the research is conclusive at this point that children raised in two-parent homes by married parents tend to do better on a host of educational and social outcomes, better than any other family arrangement. But for some reason, this is not seen as a priority oftentimes with respect to our policy, and I think it's something that we need to discuss more. And obviously, we can't fix this in one particular generation, but that's part of the reason I talked about the success sequence, so that children, way before they start a family, understand that they have a sense of agency. So if they finish school, get a job, get married before they have children, their chances of being in poverty will be in the single digits. I think it's something that every student should know before they graduate from high school.
Yeah, and you anticipated my very next question, because I wanted to raise that quote from your testimony, because it was astonishing to me to look at that and know that that is in fact a great recipe and a great formula to getting out of poverty, is to stay in school, to secure stable employment, to get married before you have children. Those factors are much more prominent than anything else, and so that traditional family environment is so important to raise our kids up and to allow them then to succeed and to do much better than we did. And that was one of the things, as I look back on my upbringing, that I credit a lot of where I am today to is certainly was not money, certainly was not influence, but it was the stability and the security of loving parents that guided me through that time to understand that my decisions would help me get further in life by working hard and by serving others and by instilling good values in me. Would you agree that that is a good formula ultimately to lead to success in this world?
Absolutely. If the first time your child is read to is when they start on their first day of kindergarten, something has gone wrong, regardless of what skin color that child is. So home environment matters a great deal as it relates to education. And I think of my own father, who was the chief education officer in our home, who stayed on me consistently because he refused to allow me to settle for a B+ when he knew that I could be an A student. So students need obviously quality schools with dedicated teachers and administrators, but they also need to have the types of home environments that cultivate a sense of wonder and a lifelong love of learning.
I love what you just said, and I'll yield back by finishing by saying this. I started my day out this morning talking to my first grader and my second grader back home on FaceTime, getting them to show me the books that they had checked out from the library and talking about their reading levels and what they needed to accomplish this week in school. It's very important. I yield back.
Thank you. I'd like to now recognize Ms. Ledger Fernandez.
Thank you so very much, Mr. Chairman and Ranking Member and our witnesses. You know, in New Mexico, in Nuevo Mexico, we pride ourselves on our diversity. It's the foundation of our state's unique and beautiful culture, and actually looked at across this country as what could a diverse nation look like? Well, it looks like New Mexico, and we're very proud of that. But New Mexico's colleges and universities, well, they also reflect that diversity. We have 30 minority-serving institutions, including 4 tribal colleges. But I'm here to say it wasn't always that way. Latino and Native American communities had to fight for their rightful place in our higher education system, because we know it's not just how much love you have at home, it's how much education you can get to go on and accomplish the things like sitting in Congress. Under the GI Bill, this is a story I say often because people don't think about it when applied to New Mexico, but under the GI Bill, my father and other Hispanos and Jews could go to our local university. But guess what? The white-only fraternity barred them, banned them. So we can see that there has been, in this beautiful state of mind, active racism, active discrimination. But what happened to that university? It became the country's first university with a Latino president at its head. And at UNM, which is our flagship university, it went from about a 31 to about a 51% Latino population in 25 years because they worked at it. They wanted their universities to reflect their state. You have to put in the hard work to make sure that our institutions reflect, like I like to quote John Adams, in miniature, the diversity that is our country. That's our founding father who recognizes the importance of diversity. And we've seen study after study that economic, education, democratic benefits that flow when you have diversity, that in so many different ways, the Supreme Court and Students for Fair Admissions versus Harvard ignored that fact. And I want to thank you, Mr. Hinojosa, for the amazing work you did to bring those benefits to light. But the decision is the decision. There are those of us who don't agree with it, but we must live by it. But that doesn't mean that we can't still work to diversify our educational institutions. Can you tell us in Congress what we can do to make sure there is more diversity at our colleges?
Yeah, and I do want to say, I'm a New Mexico State University grad, so go Aggies.
Maybe not flagship, one of our important universities. How about that?
The other flagship, as we like to say. But there's lots of options, for university, and they have to think of things comprehensively, right? Affirmative action was never the silver bullet, right? It wasn't going to get us where we needed to go. Again, it wasn't, these automatic admissions. There's plenty of extremely talented students across races and backgrounds who have been admitted through affirmative action programs. Now we don't have that as an option at most universities. We still have it available at the military academies and possibly others for other reasons, but there's still other opportunities. There's the analyzing race-neutral programs, such as percentage plans that were mentioned earlier in Washington State. You know, students attending their schools, you know, should be able to attend, you know, their state flagship. These are state flagships that should be representative of the state. And we're not talking about racial balance, and we're talking about access in a true democracy. We're talking about need-based financial aid that needs to be increased considerably, climate support. So these DEI programs that were mentioned earlier, those are actually pivotal to providing, you know, the support and building a healthy, inclusive climate that does help broaden perspectives across campuses and the like. And there's many things that Congress can do. We have a lot of options in our written testimony about how Congress can also help move the bar to ensure that racial equity is not written out of policy in our universities and institutions.
And in your written testimony that you just referenced, you also pointed out the importance of Pell Grants, because Pell Grants will help students from diverse socioeconomic, diverse racial backgrounds, but with socioeconomic need access. And I would point out that House Republicans proposed earlier this year to reduce Pell Grant funding by 22%. Imagine that, 22%. 80,000 Pell Grant opportunities go away. I'm going to have to ask you to perhaps elaborate on that in writing, because I have run out of time, but that is a way where we are cutting opportunities across our country for our most deserving students. Thank you, Mr. Chairman. I yield back.
Thank you. I now recognize Mrs. Scott.
Thank you, Mr. Chairman. Mrs. Squire, you mentioned that race should not be the only measure of diversity. I think everybody would agree with that. You ought to look at all kinds of diversity, but does the college have the right to try to have a truly diverse college students because they're going to learn from each other and they're trying to be prepared for a diverse workforce? Doesn't the college have a right to try to have a diverse student body?
I think colleges have a right to, you know, determine admission standards. Again, I'm not opposed to a diverse student body. I'm actually very much in favor of a diverse student body. Again, part of that may be ethnic, but again, a big part of it is in terms of diversity of thought.
There's value to diversity of the student body because students are learning from each other, and you're not going to learn much from a socioeconomically homogeneous student body.
Well, if a selective college has 100 students, equally broken up into black, white, Hispanic, and Asian, and all 100 went to Sidwell Academy, I'm not sure how much diversity you're actually going to get. So you may have people who you know, look differently, but in terms of their life experiences, they very much may be very much the same. So I think...
So they should try to diversify that.
What I'm saying is people on the outside will look and say this is very much a diverse class, and what I'm saying is the people will look the same.
But, okay, you can define diversity, but I think you're trying to say we should have as diverse as possible. Ms. Somlin, you mentioned that the military academies should be diversified. Can you show why they need to be diversified and why that argument wouldn't apply to other colleges?
So what I said was that the compelling interest in diversity may look a bit different in the military context than the civilian context. That said, strict scrutiny still applies to any cases involving the military academies, and I'm not certain that the military academies will be able to prove both that their use of diversity is in fact a compelling interest and that the way that they are using race is narrowly tailored to serve that compelling interest.
So you don't think diversity in the military academies is a compelling state interest?
That will need to be developed in the course of litigation. I agree that whether it's compelling, the analysis will look a little bit different than in the civilian context, but the legal standard they have to meet is still high.
If a plaintiff could prove that an admissions test is in fact discriminatory, should it be allowed?
If a plaintiff can prove that a test is discriminatory intentionally so, then that violates Title VI and possibly the Constitution at a public university.
And a legacy program where the state, like Virginia, had a policy that essentially prevented most African Americans from attending predominantly white institutions like UVA and Virginia Tech. Would a legacy program where they would not benefit by having grandparents that went there, should that legacy program with a discriminatory impact against African Americans be allowed?
Under Title VI, a program has to be intentionally discriminatory to be prohibited. The plaintiffs or challengers would have to show that a particular program is intentionally discriminatory.
So if it's just discriminatory but not intentional,
So I would distinguish between programs that have a disparate impact, that is, those that have an adverse effect on a particular racial group, but that aren't necessarily intended to be discriminatory. Title VI is not a disparate impact statute. It is what's known as a disparate treatment
Ms.
statute.
Hinojosa, we know these tests are discriminatory, that legacy is discriminatory, athletic admissions can be discriminatory, wealthy donors get in at a higher rate. When people talk merit, how fair is it to have merit without offsetting all those discriminatory impacts with affirmative action?
Yeah, I think certain parts of America, and some which are represented here today at the hearing, have such a jaded view of what meritocracy really is about and what merit is about, trying to suggest that it's anchored in many of these systemic oppressive barriers, such as legacy admissions and such as standardized test scores that really tell you nothing else about students. And they're simply used as barriers to admission to prevent certain people, including the Black and brown communities, Native American communities, from attending certain universities. And it helps them excuse it and perhaps, to sleep a little better on it, suggesting these are objective.
So, sorry, time's up. Well, you indicated that the Supreme Court did allow race to be used to a certain extent. Can you elaborate on that?
Yeah, so the Supreme Court held not that affirmative action itself is completely done away with. Race-based admissions programs, in the way that the Supreme Court suggested that they're operated, cannot continue in the way that Harvard and UNC were doing. But they can occur still at military academies because of their national security interests. There might be other interests that are defined as compelling. The court said that the way that Harvard and University measured their compelling interest in diversity was not measurable, that it was not linked to their specific goals, and that they had no end time limit on. But if a university was to identify compelling interest, for example, if a university wanted to make sure that all its doctors were leaving a medical school community and they were leaving certain parts of the
We're going to have to
community.
interrupt. We have to close up. Thank you so much.